The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your bi-weekly podcast on the Federal Courts of Appeals. I'm your host, John Ross, joined this week by Sheldon Gilbert of IJ's Center for Judicial Engagement, as well as IJ litigator Anya Bidwell. This week on the show, a 7-year delay to the start of a trial, absentee ballots for folks in U.S. territories, and the federal ban on handgun sales to out-of-state residents. Anya, let's start things off in the Second Circuit.
So this case is about this gentleman by the name of Joseph Tigano. He spent 7 years inside a New York County jail awaiting trial on charges of growing pot and possessing firearms. He asked for speedy trial any chance he got. And yet, because he chose not to do plea negotiations, these folks, the judge, the prosecutor, his own attorney, they had him undergo mental examinations 4 times. 3 on the government dime, and 1 time it was a private mental examination. So essentially, because he wanted to go to trial and see the judge and the jury, he was subjected to mental examinations and ended up waiting 7 years. And the Court of Appeals basically said that this is a pretty obvious Sixth Amendment violation to the right of the speedy trial.
So, in other words, it's his attorney as well as the prosecutor and the judge thought it was kind of suspect that he would want to go to trial, even though maybe he's probably guilty.
It was really interesting. It's like they really thought he's not right in the head if he doesn't want to negotiate about his plea agreement. He kept refusing his plea agreement, and they really felt like that deserves a mental examination because he wants to go to trial and not negotiate on the plea. And I have a timeline here, if you think it will help, to just describe what happened in this period of 7 years and how many times he actually asked to go to trial.
Yeah, so this is it's been a 7-year delay, and there's just an infinitesimal number of things that go wrong for this guy. Sheldon, can you talk more about that?
Yeah, pretty much everything that could go wrong did go wrong, from the first scheduled hearing date until the date of his actual trial. So the first day that he's supposed to be at court, or at least he thinks he's supposed to be at court, his own lawyer forgot to tell him that the hearing had been rescheduled. So he's waiting in his jail cell for somebody to come pick him up to take him to court. Nobody comes to take him to court, and he's worried, I'm going to miss my court date. And when nobody will listen to him, he says, fine, I'm going to go on a hunger strike until you give me my court date. Well, the fact that he went on a hunger strike seemed to suggest to people that maybe he's not right in the head because he was so upset about this, right?
And he wasn't waiting like a week or 2 after he was arrested for his hearing. Like, this is 6 months or so.
Right. So he's understandably getting frustrated that he keeps asking for a speedy trial and things just keep going wrong. At one point, one of my favorite examples of things that went wrong in this case, at one point, the U.S. Marshal Service, which has among its responsibilities transferring prisoners from one facility to another, actually lost him. He missed 2 of his hearing dates because the U.S. Marshal Service did not know where he was. They were not sure where they left the guy. And it took him a while for them to find him, for 2 weeks before they could find him again. So again and again and again, throughout the case, you have example after example of the courts not taking his request seriously, or just examples of incompetence again and again and again on part of the government.
If I could just clarify, I mean, they didn't lose him because he escaped or anything. They transferred him to a different jail to get a competency test to make sure he was mentally competent. But it was like the 3rd or 4th one, and all of them found that he was competent, so they were sort of unnecessary.
Right. When I say they lost him, I mean literally. It's not that he escaped; it's that the Marshal Service forgot where he put them. Like I lose my keys, they lost a federal prisoner. In another example, it took the government a year before they put together a proposed plea agreement for him. And so at that particular hearing, the judge, finally is kind of complaining that things are dragging on quite a bit. And the U.S. Attorney's Office says, well, that's really not the defendant's fault. That one is on us. That's on us. It's our fault, right? Another example of a delay that I thought was absolutely outrageous and this is kind of language from the court itself. You have one instance where the judge says the court delayed his trial and to give Tagano more time to consider a plea and said, look, quote, you spent some time in jail. I don't think waiting until January is going to really materially affect anything. So they're telling this guy, stop complaining. You've already been in jail for years without a trial. What's the big deal if we make you wait another month? Or the magistrate judge said, I think we need yet another competency exam for Mr. Tagano. And the district court judge overseeing the magistrate judge said, you know what? Whatever time it takes, it takes. Don't worry about giving him a speedy trial, quote, whatever time it takes, it takes. So again and again, you have the marshal service, the prison officials, his own defense attorney, and all of the judges in the case really being unimpressed by the delay.
Yeah, Anya, why don't you tell us about the defense attorney's role in the delay?
Sure. The defense attorney, actually two of his defense attorneys, both of them at some point asked the judge to order another mental examination. And this is really fascinating, and there is a complete disregard for this guy's time, right? Just like Sheldon mentioned, even judges thought, hey, you spent this much time in jail, so what, another year? And when you hear oral arguments in the case, you can really feel Judge Pooler, she ended up writing the opinion, being absolutely outraged over this. How in the world would you have such a disregard for this person's time? And so oral arguments were held on October 12, 2017, right? And the appellate court issued an order for the guy to be released on November 15, 2017, way before the opinion itself was issued. And I think it really shows that the appellate court judges, were so upset over the disregard of this guy's time that they didn't want him to wait until they actually formally issue a written opinion to get released.
You know, the other thing that I thought kind of added insult to injury for Mr. Tagano is that the other reason that he spent so much time in jail is because of his co-defendant, who was his dad, right? His dad wanted to take the plea agreement and kept asking for the trial to be delayed, so that he could have more time to negotiate a plea agreement with the government. And in fact, the government kept offering what it called a 2-for-1 plea deal, where both the dad and the son both had to agree to plea out in order for either of them to be able to accept it. So there's this sense that the dad was intentionally delaying his son's trial for his own benefit, right? So, and Mr. Tagano Jr., or the third actually, kept saying, can I have my trial and process separated from my father? Because he clearly wants to take the deal. I don't. So let me go to trial and he can do his thing.
And of course, what's fascinating about this is that the father was a free man. Unlike Joseph Tagano, he was not waiting for his day in court in jail. So he really wasn't worried about the timing issues here.
This is going to make for a really awkward family reunion.
All right, well, just one more thing. We talked about all the different delays, but one more delay was that the court's transcript writer took months and months and months to release transcripts of like one-day hearings. There were several different delays by the transcript writer, but that was the one that seemed to stand out the most for the court. There was a one-day hearing, and everyone had to sit on their hands for 4 months while they typed it up. All right. Well, should we move on to the next case? So this case reminds me of a case that the Supreme Court just heard earlier this month called McCoy v. Louisiana, where a gentleman who was accused of committing several murders did not want to plead guilty. He wanted to go to trial. His lawyer looked at the evidence and said, man, there's overwhelming evidence of guilt. I'm going to plead guilty over your objections. And so the Supreme Court just considered this month. We don't have a decision yet, the case and what that means. But that seems to tie in here, doesn't it, Sheldon?
Yeah, I think that, there's this fundamental question, which is when you have a criminal justice system that is designed as a factory to produce a particular type of outcome, and that outcome is a conviction, and a conviction can be as the result of a trial, which is fairly inefficient, or as the result of a plea agreement, which is 97%, I understand, of federal convictions are the result of plea agreements. You have a machine that's designed to do that. And the prosecutors and the defense lawyers and the judges are all basically on the same side in this machinery. And whether it's in the McCoy versus Louisiana case, where the defense attorney says, I understand how this machine works, and it's crazy for you to ask for a trial, so I am going to ignore your demand to plea not guilty, and I'm going to enter a plea of guilty. Or it's this case where the defense counsel says, I think you are actually crazy to not accept a plea agreement and to claim that you're not guilty. Therefore, I'm going to get the court to have you take competency exams over and over and over again for 7 years, for a 7-year period. In both of these cases, you see that the entire system is aligned against the defendant. And the other interesting thing is in that McCoy versus Louisiana case, look, if the Supreme Court decides that it's okay for a criminal defendant's attorney to ignore what the criminal defendant wants to plea and just choose to plead guilty anyway, then in Mr. Tigano's case, it would have been even easier for his defense counsel to resolve this case quickly. The defense counsel could have just said, hey, Joe, I don't care if you want to go to trial. I'm going to ignore you, and I'm going to enter a guilty plea on your behalf. And if McCoy versus Louisiana comes out the way Louisiana wants, then Mr. Joe Tigano's lawyer could have done that. And he would have gone straight to jail without this, without a hearing.
So those are criminal cases, but this also, these kind of delays come up in the civil context. For instance, an IJ case right now in Eagle Pass, Texas. Anya?
Yes, actually, in our civil forfeiture cases, we have somewhat similar situations. So the Eagle Pass case that you just mentioned, our client Gerardo Serrano was stopped at Eagle Pass border, U.S.-Mexico border, and the Customs and Border Protection agents essentially took his truck and kept it for 2 years without allowing Gerardo to see a judge. And here's the thing, he kept contacting CBP and he kept saying, hey guys, I really want to see a judge. When am I going to get a chance to see a judge? And they kept telling him, well, because you chose to go to trial instead of negotiating with us or instead of accepting administrative forfeiture, you will have to wait a while. And so basically it's kind of very similar in that situation where, just like Mr. Tigano, Gerardo really wanted to see the judge. He didn't want to negotiate on on the government's terms. He wanted to go and see the judge. And as a result, he was forced to wait for 2 years. And quite frankly, had we not filed that federal lawsuit, I doubt he would have his truck back today.
Now, Gerardo isn't alone, right? I mean, this isn't something that just happened to Gerardo. This happens pretty frequently at the border.
Yes, it does. That's why we're filing a class action lawsuit. So Gerardo is a representative of a class. He's just one example.
Right, so he's gotten his truck back, but the lawsuit lives on because there's so many other claims.
Absolutely. The lawsuit lives on. It's a class action lawsuit as well as a Bivens lawsuit where we suing for damages because quite frankly, when you don't have your truck for 2 years, when it sits out there baking on the sun, the government doesn't just get to say, hey, nothing happened here. Here's your truck. You have no claims.
Yeah, and also he was making payments on the loan for the truck, and he had various costs associated with the truck that make for a damages claim. Let's move on to the next case, which comes out of the Seventh Circuit. Sheldon?
Sure. This case comes out of a federal statute that was passed some years ago. It's called the Uniformed and Overseas Citizens Absentee Voting Act. And based on the name, you could probably guess what the purpose of the statute is. The statute is designed to make it so that United States citizens who move overseas but are still American citizens have an opportunity to vote by absentee ballot in U.S. federal elections. Now, what the statute does is it requires states who set the laws within their states for how voting takes place. It requires states to permit overseas voters to use absentee ballots. Now, the question then is, what is an overseas voter? What does overseas mean? Well, overseas could literally mean anytime you are over the sea, right? But when we say that if I move from the great state of Virginia to Hawaii, even though I've literally gone over the sea, we don't consider Hawaii overseas. Overseas has a different definition. And in fact, the statute provides a definition of overseas. And it says that overseas means not in the United States. And when federal law defines United States, federal law says United States means the several states, the District of Columbia, the Commonwealth of Puerto Rico, Guam, the Virgin Islands, and American Samoa. So the United States includes not just states, but also territories. What does all this mean? This means that under the statute, the federal government requires states to provide a mechanism for people in, say, for American citizens in, say, Iraq to do absentee ballots, but it does not require states to provide absentee ballots for U.S. citizens who move from Illinois to Puerto Rico or Guam or another U.S. territory. All right. So Illinois then passes its own law that implements this federal requirement. So again, federal law says you have to provide a mechanism for those who are overseas. Overseas doesn't include United States, states, and territories. So when Illinois passes its law, it does allow individuals who are Illinois residents who move to the territories of American Samoa or Northern Mariana Islands to do absentee balloting, but it doesn't allow Illinois residents who move to those places listed in the statute as part of the United States, D.C., Puerto Rico, Guam, and the Virgin Islands, to do absentee ballots. So this lawsuit is brought under the 14th Amendment Equal Protection Clause and argues that it is a violation of equal protection for Illinois to provide a mechanism for Illinois residents to move to the Northern Mariana Islands to vote by absentee ballot, but not for Illinois residents who move to Puerto Rico or Guam or American or other places like that.
Anya, what does the Seventh Circuit make of that claim?
It's a very interesting opinion, and the Seventh Circuit does not buy it. It basically says that the statute produces an anomalous result. The state Illinois statute produces an anomalous result. However, it's still going to uphold that statute as under the rational basis review. So it gets there through two different mechanisms. First, the appellate court says that when it comes to American territories, the right to vote is not fundamental. Right, and the trial court actually also came to that conclusion, but it cited insular cases to get there. And the problem with insular cases and getting to whether the vote is fundamental or not is that this is an infamous line of cases at the same time as Plessy versus Ferguson, when the United States Supreme Court basically said, hey, the Bill of Rights applies in the United States of America, but when it comes to territories, we don't take it as seriously. But the Court of Appeals does not really rely on insular cases. It basically says, given that the territories send no electors to vote for president or vice president, and given that they have no members in the United States Congress, their right to vote is not fundamental. As a result, it triggers rational basis review rather than strict scrutiny. And plaintiffs and petitioners in this case were arguing for strict scrutiny. And so since it is a rational basis review, the level of review is really low, and the appellate court looks to 1979 when the Illinois enacted this statute to see whether there is a rational basis for this statute to exist. And it says, hey guys, in 1979, there was completely good reason for why we treat Guam, Puerto Rico, and Virgin Islands one way, and Samoa and Northern Mariana Islands the other way. Samoa and Northern Mariana Islands were not nearly as well integrated into the fabric of the United States. And so it says, given this analysis, given that the law was rational when enacted in 1979, we're going to say that it passes rational basis test. And the court also says, even if the plaintiffs were correct and the definition and basically the law became irrational at some point in, say, circumstances that are today, because territories are much more similar today than they were before, it would not help plaintiffs in this case. We would have to contract voting rights rather than expand them. Therefore, we choose not to look at the rationality of the law as it is today, and we're going to look at the rationality of the law as it was in 1979, and we're going to say that the law is rational and must stand.
So here's the thing about this entire case. I think the entire thing is weird. I find it strange that residents of Puerto Rico are trying to create this backdoor mechanism to obtain rights to vote in a federal election. Look, we can have a debate about whether or not Puerto Rico and Guam and American Samoa should be states and should, be voting in federal election. And that's a really good and important debate to have. But I keep getting stuck in the plain language of the Constitution, separate from what the court did. I can't help, but I'm pulling out my pocket Constitution here. But turn to Article 1, Section 2, and it says that the House of Representatives shall be composed of members chosen every second year by the people of the several states. Puerto Rico is not a state. If we go to Article 2 about choosing the president, Article 2 says the executive power shall be vested in a president of the United States, and each state shall appoint in such manner as the legislature thereof may direct a number of electors, et cetera, et cetera, et cetera. So it's the states that have the responsibility for choosing who the federal officers are. And to me, this lawsuit seems to provide a backdoor mechanism to get around the plain import of the Constitution that states, but not territories, decide who runs our federal government. And that, I think, is ultimately what I find, troubling and unpersuasive about the whole thrust of the lawsuit. Now, Anya points out something really important. When the court decides that rational basis review applies, I think the court says something that is deeply troubling. The court says that, fine, this may have been rational in 1979, and maybe it's not rational now, but we're just going to look at what was rational in 1979. And to me, that doesn't seem right. It can't be that if we're really doing rational basis review, it only applies the constitutional right. If it could be ignored at some point, it can always be ignored through time immemorial, even though the conditions that justified ignoring or trampling over that right justified doing so a long time ago. So I think that part of the opinion is troubling. But ultimately, I am not a big fan of the plaintiff's lawsuit in this case.
Yeah, IJ has challenged the so-called changed circumstances in cases regarding funeral homes, where, it might have made some sense in the 1950s when mortuary science wasn't as advanced and dead bodies were, posed more of a threat of disease than they do now. They didn't have quite so modern refrigeration. And laws that might have made sense to keep funeral homes more safe in the 1950s really don't do anything like that today. And what they do today is allow for cartels and make otherwise reasonable economic transactions unlawful. Anya, tell us some more about changed circumstances.
Yes, changed circumstances doctrine is absolutely fascinating. And the case that you're referring to is Hefner versus Murphy. IJ filed a certiorari petition begging the United States Supreme Court to finally take up this issue, whether when we are applying rational basis review test, we need to look at the law as it was enacted at the time when it was, at the evidence of the law when it was enacted, or we should look at whether the law is rational as applied today. And it all stems from this case, Caroline Products, right? And Caroline Products specifically says that the constitutionality of a statute predicated upon the existence of a particular state of facts may be challenged by showing to the court that those facts have ceased to exist. And this is the best sort of Supreme Court authority on rational basis, changed circumstances test that we have. And since Caroline Products, a lot of circuit courts applied this changed circumstances doctrine to its own cases. For example, 10th Circuit did. And ironically, 7th Circuit, even though it is kind of ignoring changed circumstances here, applied it before in this distinction between crack cocaine versus powder cocaine case. And also the Supreme Court, in other cases, not necessarily rational basis review cases, but like a Voting Rights Act case, Shelby County versus Holder, also uses this changed circumstances test, where it basically says current burdens must be justified by current needs, right? And it strikes down Section 4 preclearance formula for certain states. So there is a whole bunch of case law out there where you have Supreme Court applying current evidence when analyzing certain cases for constitutionality, where lower circuits applying changed circumstances doctrine when using rational basis review test. But what we really need is for the US Supreme Court to take up the case similar to Hefner versus Murphy, the Pennsylvania funeral law case, and to finally say, listen, Caroline Products meant what it said. If circumstances change, then the rationality of the law might also change.
Okay, and that actually makes for a great segue to the next case. The last case involved changed circumstances in a rational basis review case. This next case involves changed circumstances in a strict scrutiny case. Anya, can you tell us about the next case, which comes out of the Fifth Circuit?
Absolutely. So this case is a Second Amendment case. It involves a federal law according to which you can't buy handguns from a federally licensed firearms dealer unless both you and the dealer are residents of the same state. Right? This law does not apply to shotguns. It does not apply to rifles. It only applies to handguns. Is there a Second Amendment violation? The trial court, Judge O'Connor, said, heck yeah, there is a Second Amendment violation. And he basically granted plaintiffs' motion for summary judgment, saying that the statute is unconstitutional both as applied and facially. But the Court of Appeals reversed the lower court's judgment and said that the statute is actually not unconstitutional. More than that, it survives a very high level of review, strict scrutiny. And what's really interesting about this case is that Judge Priscilla Owen writes for the majority, and then she also writes a separate concurrence. And those are essentially the only two opinions that exist at the appellate court level. And I haven't seen that very often, where you essentially just see one judge writing for the majority and then the same judge writing a concurrence. And when she writes for the majority, she basically assumes that strict scrutiny applies here, and that the law that requires federally licensed firearm dealers to sell only to residents of the state where the dealer is a resident, that it survives a strict scrutiny review. It says, first of all, that there is a compelling interest, government's interest in preventing handgun crime through stopping circumvention of state and federal laws. And it says that the law is narrowly tailored, right? That you can't expect federally licensed firearm dealers to know laws of every single state, but you can expect them to know the law of their own state. So therefore, it makes sense to require them to sell guns, handguns, only in their state. And she also says that the separation between handguns and long guns makes sense because, as current evidence shows, right, not the evidence when the law was enacted, but as current evidence shows today, handguns cause much more violence than long guns do. And she cites Shelby County versus Holder for the proposition that we must analyze the evidence today. And so this is a pretty straightforward application in her majority opinion. And then in her own concurrence, she seems to kind of, in an indirect way, to ask the US Supreme Court to clarify Heller, right? Heller was a monumental Second Amendment decision that came down in 2009, and there was McDonald, the decision that came thereafter, but essentially it was very similar to Heller, and there are gaps left by Heller that Priscilla Owen seems to kind of encourage courts to take up a Second Amendment case, the U.S. Supreme Court, and fill in those gaps. For example, Heller says that it is presumptively lawful to impose conditions and qualifications on the commercial sale of arms. And what she's wondering is whether it is, if banning the sale of handguns, completely banning them, is one of those impositions of conditions and qualifications, and whether that would be presumptively lawful. And she thinks surely not. And also, I think she is kind of asking the court to clarify whether strict scrutiny or intermediate scrutiny applies in this case. There is essentially a circuit split now. Seventh Circuit basically says, hey, we just only gonna apply intermediate scrutiny. It's just too difficult to wade into waters of intermediate scrutiny versus strict scrutiny. And then you have courts like Fifth Circuit and Second Circuit. They basically use a two-step analysis, and they first ask, does challenge law impinge on Second Amendment right? And then based on that answer, they select whether it is an intermediate scrutiny or strict scrutiny. So that's essentially the two opinions in a nutshell.
I have a theory about what's going on with that concurrence. If you notice, the three-judge panel includes not just Judge Owen, but two other judges, Judge Prado and Judge Haynes, who were also on an earlier panel in 2012 considering another Second Amendment challenge. And it was a challenge to a prohibition on gun sales to individuals under the age of 21. And in that case, Haynes and Prado also voted in favor of upholding the gun legislation. So you have two judges who have already been on record as supporting, certain gun regulations. And then you get to this case, and you have this debate that Anya suggested. What level of scrutiny applies for the Second Amendment? Is it strict scrutiny? Is it intermediate scrutiny? Is it, as the government said, rational basis scrutiny in certain circumstances? And the court's formal opinion says we're not going to decide that, but the legislation would withstand even the most harsh standard, the strict scrutiny standard, so that's why we don't need to decide it. But then in the concurrence, Judge Owen says, well, by the way, I really think it should be, strict scrutiny, right? I don't buy the government's argument that it should be rational basis review, and kind of very strongly criticizes some of the government's arguments. And I kind of wonder if in order to that she really thinks that that's the level of scrutiny that ought to be required, but she couldn't get the other two judges to sign off on that, and that's why we have kind of the squirrely majority opinion. And then, as Anya suggested, the concurrence is really asking for the Supreme Court to step in and settle this question.
Okay, that concludes the show. Thanks for listening, and be sure to tune in next time for more judicial engagement. Until then, this is John Ross from the Institute for Justice, conditioning you to get engaged.